Welcome everyone. This is part of the Garden Court Chambers 70th anniversary of the ECHR series, and tonight we're going to be talking about rights and children and using the convention in youth justice cases. Just so everybody is aware, you will have been placed on mute, but we want you to be active participants in tonight's seminar. So there is a Q&A window that you can place questions in. The chat function is also enabled for other comments, queries or feedback. But please don't post questions in the chat bar, use the Q&A function where you'll have an opportunity to vote on those questions that you most want answered. I can also let you know that the resources that you will see, the PowerPoint presentations, will be circulated to registered delegates after the webinar, and the webinar is being recorded. That means that anybody who speaks is recorded, the audio and video of panelists, but you are not going to be seen on screen. The webinar may be shared in our marketing channels, including our website and social media. Please refer to the instructions in the chat window if you are experiencing any technical difficulties. So welcome. Tonight's webinar is going to be very exciting, and I'm delighted to have our three speakers with us tonight. We're going to hear first from Henry Blaxland talking about using the ECHR to protect victims of trafficking. And then we're going to hear from Fatima Jichi, who's going to talk about, in more practical terms, about the challenges for practitioners in the youth court who want to raise arguments under the Modern Slavery Act to protect victims of trafficking facing criminal prosecution. And finally, Jo is going to give us a whistle-stop tour of the ways in which the rights of children have been protected in criminal cases using convention rights. And before we embark on this fascinating seminar, I'm delighted that tonight also marks a very significant event, that Garden Court Chambers is launching a new specialist team. Recognising the expertise that already exists in Chambers, we are launching the Youth Justice and Child Rights team. All of the members of the panel are members of this team, and we are taking this opportunity to recognise the special rights and protections that are afforded to children in the criminal justice system, and ensure that our expertise is used by those instructing us to ensure children's rights are protected. We hope to have a proper opportunity to launch this team in due course with Garden Court's usual hospitality. So I turn to Henry Blaxland first, whose reputation precedes him. He is a leading criminal silk, but he also has used his expertise to develop a line of authorities that have established protections for victims of trafficking, and he's going to share with us this evening the story and the history of how those protections have been fought and achieved. I'll turn to Henry.
Well, good evening, everybody. 70 years since the drafting of the ECHR. In fact, it didn't come into force until September 1953, which was just a year before I was born. So it's quite a thought to think that for my entire life, the ECHR has been in existence. But perhaps also interesting that it's only in relatively recent times, or certainly in terms of my lifetime, that its full impact has been felt within domestic jurisprudence. Now, what I'm going to do this evening, as Kate has explained, is to look at the ECHR in the context of the protections which are provided to victims of trafficking. And I'm going to start, I've divided my talk into really three headings. Firstly, the genesis and the development of the principles governing the protection of victims of trafficking. Secondly, the Modern Slavery Act 2015. In particular, I want to look at some of the problems of interpretation of the Act and consider the extent to which the Act, in fact, discharges its stated purpose, which was to give domestic effect to the international obligations. And then finally, I'm going to look briefly at recent developments in the law, because what's extraordinary about this field is that there continue to be areas which the Court of Appeal in particular have had to consider. And when I've finished, we're going to turn to probably the more important aspect of tonight's seminar, which is Fatima talking about the practical application of these principles, because it's all very well to look at the principles themselves, but we need to see how they work out in practice. Now, can I then bring up on screen the PowerPoint? I'm a bit of a novice with this, so you have to bear with me if it doesn't work, but here we go, the first slide. Need to see how I can move down from one to the next. Hang on. Try to work out how I can move from one slide to the next. Oh, sorry about this. Worked perfectly well earlier on when I was, here we go. First slide. So that's the introductory slide. And we start with Article 4, prohibition of slavery and forced labor, which you'll all be familiar with. No one shall be held in slavery or servitude. No one shall be required to perform forced or compulsory labor. Principles which are expressed in very general terms. What is of some interest is that it wasn't until the additional international instruments were brought into force that the relevance of Article 4 began to become clear. And we start, therefore, with the Palermo Protocol and the European Convention against trafficking. And what you have on screen is the relevant extracts from a judgment in a case called Joseph and Others, which was 6 conjoined appeals, which were heard in 2017 and concerned various aspects of the trafficking protections which the Court of Appeal was addressing. But Lord Thomas's summary of the background provides, I think, the most helpful and extensive explanation or exposition of how the principles have developed. And we start with the Palermo Protocol, 2001. The UN Protocol Convention against trafficking, against transnational organized crime, and came to force in February 2006. And you'll be familiar, no doubt, with the definition of trafficking, which was contained in Article 3 of the convention. Of the trafficking protocol. I'm just trying to move things on the right of my screen so I can see the full thing. And the definition of trafficking you'll be familiar with in Article 3, which was subsequently replicated in the trafficking convention in Article 4. So if I can just go back to the previous slide. Somebody can just help me take me back to the previous slide, because oh God. Which sets out the definition of, yes. Well, the definition of trafficking, which has been introduced by ECAT and the Palermo Protocol, was then considered in the seminal case of Rantsef and Cyprus and Russia by the ECHR. And the importance of this is that in Rantsef, the court concluded that trafficking within the meaning of Article 4A fell within the scope of Article 4 of the ECHR, which was a significant and important development. Most recently, in the case of MS Pakistan, the authority of RANSEF and its application to domestic law has been fully recognised. And I've set out there on the screen the two relevant passages from the decision in RANSEF in MS Pakistan. MS Pakistan is an immigration case, but the principles are of wider application, and it is of a case of some importance. Although the court judgment given by Lady Hale noted that it wasn't necessary to decide whether all the positive obligations in ECAT were incorporated into the state's positive obligations under Article 4 in order to decide this appeal. So that's the context. You have the definition of trafficking, the broad definition of trafficking within Article 4 of ECAT and paragraph 3 of the Palermo Protocol, then effectively aligned, if you like, with the provisions of the anti-slavery protection in Article 4 of the ECHR. And we then move to the Modern Slavery Act, intended to give domestic effect to the anti-trafficking protections, and providing, as criminal practitioners well know, the new defence under Section 45, the defence of slavery or of trafficking victims who commit an offence. And I'm just, you'll be familiar with this, but I'm just briefly going to go over it. Person not guilty of an offence if the person is aged 18 or over when the person does the act. The person does that act because the person is compelled to do it, and the compulsion is attributable to slavery or to relevant exploitation. And I'm going to explain in a few moments why I have highlighted that particular passage. Subsection 3, which is the section which is of direct application to children, those under 18, compulsion is attributable to slavery or to relevant exploitation only if it is always part of conduct which constitutes an offence under section, just a minute, under sorry, it's my, under section 3, there's a person is not guilty of an offence under section 4 if the person is under the age of 18 when the person does the act, and you'll be familiar with that. We then move to subsection 5, and this is where the problems, I think, start to come in with the interpretation of the Modern Slavery Act. Relevant exploitation is exploitation within the meaning of section 3, that is attributable to the exploited person being or having been a victim of human trafficking. And that means, of course, when anybody raises this defence, you then have to analyse exactly, you have to analyse the individual components, which means tracing your way through the definitions within the Act. So we then go to sections 1 to 3. If I can just go to the next slide for some reason. It's not allowing me to move down to the next slide. Oh, God. No. Hooray. The meaning of exploitation. And I'm going to move backwards. I'm going to start with section 3, the meaning of exploitation. For the purpose of section 2, a person is exploited only if one or more of the following subsections apply in relation to the person. Slavery, servitude, and forced or compulsory labour. The person is the victim of behaviour which involves the commission of offence under section 1. So in this rather convoluted way, the section takes you back to the earlier sections. And of course, what the Modern Slavery Act did was to start by creating 2 criminal offences, slavery in section 1 and trafficking in section 2. What it went on to do through section 45 was to fashion the section 45 defence around the creation of these new offences, which seems to me has created problems. One way, exploitation can either amount to an offence under Section 1, or where the person is subjected to false threats or deception designed to induce him or her to provide services. So that may or may not apply, possibly in county lines cases, I'm not entirely sure. We then go to the definition of human trafficking, which is in Section 2. The person commits an offence if the person arranges or facilitates the travel of another person with a view to the victim being exploited. And it's worth noting, of course, that arguably this restricts the definition of trafficking within Article 4 of the protocol, because, of course, and this is important, human trafficking can be committed simply by the recruitment of somebody for the purpose of exploitation if they are a child. Clearly, if they are an adult, the means of trafficking also have to be established. But if you're a child, the means themselves don't apply. So it's simply recruitment for the purpose of exploitation. Human trafficking within Section 2 requires it to be proved that the person commits the offence if the person arranges or facilitates the travel of another person, which is effectively, on one view, more restrictive so far as the offence is concerned, but less restrictive so far as the defence is concerned, if you see what I mean. And then let's move to Section 1, which is the offence of holding another person in slavery or servitude. And in subsection 2, we find this. In subsection 1, the references to holding a person in slavery or servitude, requiring a person to perform forced or compulsory labour, are to be construed in accordance with Article 4 of the Human Rights Convention. What does that mean? And this may be where the significance of Article 4 really comes into force, if you like, because arguably what that means is that in construing the definition of exploitation, which we were looking at in Section 3, you go back to Article 4 of the Convention, and of course Article 4 of the Convention has to be construed in accordance with the decision of the European Court in Rantsef. Now, the reason that I mention all of this is partly because I've had to argue this point in a case involving a young person who is charged with terrorism offences, in which his case is that he was recruited by an online groomer, all right? And so the issue arose as to the extent to which his case as to how he became involved raises questions under Section 45 of the Modern Slavery Act. And in particular, the extent to which simply recruitment for the purpose of exploitation is sufficient for a defence under Section 45 of the Act. Anyway, it's for that reason that it seemed to me that it was important to consider, at the very least, the rather convoluted way in which the Modern Slavery Act has been constructed, and what it seems to me are the problems with interpretation. How important they will be in practice, I'm not entirely sure, but it's an act which has certainly attracted a certain amount of criticism. Can we then move on to what was said about Article 4 and its application in the case of DS? Now, DS, as you will know, I'm sure, is the relatively recent case in which the Court of Appeal decided that the protection afforded by the abuse of process jurisdiction ahead of the introduction of the Modern Slavery Act was no longer apposite, or was to be confined at the very least to cases involving state malpractice. And DS was a case in which a young defendant raised the Section 45 defence. He was referred to into the NRM, as a result of direction by the judge. The competent authority concluded that there were conclusive grounds to believe that he was a victim of trafficking. And as a result of that, the prosecution continued with the prosecution. As a result of that, the defense argued that it would be an abusive process to continue with the prosecution because the prosecution had effectively overridden the decision of the competent authority. The judge agreed with that. The prosecution appealed. The Court of Appeal decided that the judge shouldn't have entertained an abusive process application because the solution was the defense under Section 45. And in its judgment, the court turns its attention to the decision in Rancef and its application, because our submission to the court in DS was that by virtue of the decision in Rancef, the Court of Appeal had a direct responsibility to protect the victims of trafficking, as do all courts, and therefore the court considered the extent to which Article 4 applied. And as part of its judgment, it observed, and I'm sorry because part of my screen is obscured, and I've highlighted this passage, we do not think that there is any basis for deriving a positive obligation not to prosecute victims of forced or compulsory labour in Article 4 of the ECHR. And you'll recall, of course, that Article 26 of the Anti-Trafficking Convention, the non-punishment provision, is the protection against inappropriate prosecution for victims of trafficking. That comment that Article 4 of the European Convention does not provide a positive obligation not to prosecute is frankly controversial. DS was decided before the decision in MS Pakistan, and it is certainly arguable that applying Rancef, which effectively decides that the Palermo Protocol and the European Anti-Trafficking Convention provisions are directly relevant to the interpretation of and the application of Article 4 of the ECHR. And of course, those protections undoubtedly include the non-prosecution protection. So whether, again, this is going to matter in practice is a different thing, but it is arguable at the very least that that observation DS is not right in law. And just going again down to the next slide, my system, I'm very sorry everybody, my system seems to allow me sometime to move slides, but then stops me from moving on the next occasion. What I'm going to move on to anyway, and maybe the new slide will come up, is just to consider very briefly the most recent developments in the law. Because there are still cases which are being decided. There have been two. There's been a recent case called A, in which the Court of Appeal held that the decision in DS applied equally to those who were charged with non-Section 45 offences, in other words, offences which fall within Schedule 4 of the Act, and therefore to which the defence under Section 45 is not applicable. And in DS, and in the case of A, the Court of Appeal decided that that the same principles apply, although in other words, the abusive process jurisdiction does not. Abusive process jurisdiction does not.
I think we're getting some assistance with your slides.
Hooray, we've got there.
Somebody will move them for you.
Yeah. Well, I'm just referring to the case of A, which you need to know about. That was
That's the previous slide.
Case of A.
Thank you.
It's to do with in this case, the defendant was charged with aggravated burglary, which is a serious offence to which the Section 45 defence does not apply. and the court held the abuse of process jurisdiction again doesn't apply to that. So effectively, if the prosecution decide to go ahead, short of some fundamental error, the court will not interfere with it. Although it is of some importance that in that case, the Court of Appeal decided that where the trial court and the prosecution had failed to consider the question of whether or not there were trafficking issues arising, the court would itself decide whether or not the prosecution should have proceeded. In other words, the Court of Appeal will continue to provide some protection to people where the issue simply hasn't been considered at the time of trial. And then finally, where are we at the moment? And this is where the law, in my view, is in its most interesting state of development. And it's the question of the status of the national referral mechanism and decisions which are made after a referral by the single competent authority. It's worth noting that in Section 52 of the Modern Slavery Act, there is a statutory duty to refer into the NRM where there are reasonable grounds to believe that a person may be a victim of slavery or human trafficking. And so first responders have a statutory duty. As we know, a judge is in a criminal court is not a first responder, but a judge can, on the other hand, direct a first responder to refer a defendant into the NRM. And that brings us to the ongoing issue of the admissibility of decisions of the single competent authority, where there have been conclusive grounds for deciding that a defendant is a victim of trafficking. In the case of SG, the Court of Appeal held that, although it wasn't relevant to the decision, that decisions of the competent authority were on conventional lines almost certainly not admissible, but fairness would require them to be introduced in some way or another. In the case of DS, we specifically invited the Court of Appeal to consider the question of the admissibility of decisions of the single competent authority, but they declined to do so. They said that would have to wait for a suitable case to arise. Well, it appears there is a suitable case, which is going to be heard by the Divisional Court next week. Sam Parham and Brenda Campbell from Garden Court will be appearing for the respondent, because it's a case stated prosecution appeal from a youth court decision in which the district judge had effectively stayed the proceedings on the basis that the conclusive grounds decision was determinative. I say that actually, I'm sorry, I'm going to correct myself. In fact, I think that the trial proceeded and the defendant didn't give evidence and he was then acquitted rather than the proceedings being stayed. And he was acquitted, interestingly, without giving evidence, relying upon the single competent authority's decision. And the prosecution have appealed that. And it will be very interesting to see what the outcome of that is. So after many years of the appeal courts considering how to apply the protections to victims of trafficking and how to apply them in particular in the case of young people, because it's in the case of young people, children, that they are particularly relevant, it seems to me. But after years of the cases going backwards and forwards to the court, to and from the Court of Appeal, there are still outstanding issues. And this perhaps is the biggest issue because there is, it seems to me, a very real tension between the state's duty to protect victims of trafficking, for which the national referral mechanism is the principal means which is adopted, and the protection against prosecution, where broader questions of the public interest in prosecution come into play. Well, thank you very much indeed. And I'm going to hand over now to Fatima. And I'm very sorry for my incompetence in dealing with that slideshow. You live and you learn, or maybe you don't.
Well done for surviving your technical challenges, Henry. I think we've all faced the challenge of screen sharing and PowerPoint, so well done. And thank you for that fantastic analysis and providing context for the position that we now are in, which, of course, for many of us is not in the appellate courts, but it is in day-to-day dealing with children in the youth court. And so we are now going to turn to Fatima, who's got a mixed practice, but a particular interest in representing children and children in the youth court, and brings with her a huge wealth of expertise from working in the with non-governmental organisations before coming to Garden Court. So we're very privileged to have her sharing her expertise and analysis of the practical challenges in the youth court. So I turn now to Fatima.
Thank you, Kate. I'm just going to start by sharing my screen. Hopefully that works. So following on from Henry's update on the law, I thought it would be helpful to take you through some of the issues that I've faced in the youth court. It's important to note that there doesn't seem to be a uniform approach taken by the CPS to dealing with these kinds of cases in the youth court, but hopefully this will help you get a sense of the practical issues that arise when defending trafficking cases in the youth court. To begin with, I think we should routinely be exploring issues of trafficking as early on as possible. We know that, for example, no common interviews are used against defendants at trial. So trying to raise these issues at the earliest opportunity can really make a difference. Even at the first appearance stage, even where there's not been an NRM referral or an NRM decision, it's worth highlighting that there is a possible Section 45 defence at that stage. And that can be really important in, for example, preserving credit at that stage, because a lot of children especially are advised to plead guilty to preserve credit, and that could be a way to get around that. It's also helpful at that stage to raise, because of case management, to allow some time between the first appearance and trial to allow an NRM referral to be made, and to allow time for representations to the CPS and to gather any other expert evidence. Now, sometimes this issue comes to light after plea is entered. If it's not too late, I'd advise applying to vacate plea as soon as it becomes apparent that this defence is now available. And I know that Chambers is hoping to organise a seminar soon on how to deal with cases where the NRM defence, the Section 45 defence becomes available post-sentence, so keep an eye out on that. Once the issue is raised, the next stage is referral to the NRM, which I think Henry has already touched on. The NRM was set up to comply with the state's obligation to identify victims of trafficking, and referrals need to be made through a first responder. And I've just included a list of first responders on this slide. But I think it's important to note here that solicitors can make referrals to one of these first responders, and it can be very helpful to have solicitors involved in the process. And certainly there have been times where it's been really difficult to get disclosure when referrals are made by the police, and so having solicitors involved is really, really helpful. There is, of course, a duty to refer, as Henry mentioned, and it's important to note that where the potential victim of trafficking is a child, an NRM referral does not require the child's consent. Once the referral is made, there is a reasonable grounds decision, which should take place within 5 working days. Often that time frame is much longer. I have remarkably had decisions in 5 working days, but that is incredibly rare. And I know some of my colleagues are waiting 4 months for a reasonable grounds decision. And then 45 days from then, that's when you're expected to have a conclusive grounds decision. But again, I'd say 4 to 6 months is far more of a realistic time frame, particularly now during the pandemic. And 45 days following the reasonable ground decision, the child should have access to appropriate help and support, including legal advice, accommodation, protection, and independent emotional and practical help. Again, the reality is that support is often not available. I've had a very good experience recently in one of my cases where the local authority, within a month of the decision, took the child into care, supported them to find a placement in college, semi-independent accommodation, and supported them to get help for enrolling in internships, etc. So when the system works, it really can have such a big impact on a child's life. And so that's really my next point, which is to actively consider the support that is available and be proactive in seeking that for our clients. And that's where a multidisciplinary approach to solving legal issues can be helpful. Not only will this have a really big impact on often a very vulnerable child, but it's also helpful for trial purposes, because some cases can take months and months before they get to trial. And often once a child is removed from that environment, they do very well. And that's something you can use to argue in trial to prove nexus, to prove that once a child has been removed from circumstances of exploitation, there's been no reoffending since. So that could be a good way of showing that there was a relationship between the offending and the exploitation. And it's also helpful in terms of representations to the CPS to review, and in terms of mitigation to show how far the child has come since receiving the support that they need. And that brings me to my next point of representations. I cannot stress this enough. Sometimes after the first set of representations, you don't get very far. And so you just think, well, is there a point of doing a second round of representations? But we have had some success with multiple representations. And then at the third time of asking, the CPS have agreed to drop the charges. So it is worth persevering. And I'd say particularly whenever anything new comes up, so they've got a continuing duty to representation. So if you've got a psych report that now says something new, that's grounds for them to do further representation. If there's any disclosure, that's again grounds for them to review. So it's worth following that up. Now, the CPS website does have guidance on reviewing these cases, and they take a 4-stage approach to deciding whether to prosecute. The first stage is really focused on whether there is reason to believe that the person is a victim of trafficking or slavery, and where there is reason to believe that. And I think that is probably easier to tick that box at the review stage than it is at trial, where it's simply if you've got the NRM decision, that should satisfy that first stage of the test. Then they consider whether there's evidence of common law defence of duress. Then they move on to consider whether there is if it doesn't meet the threshold of duress, then they consider whether it's a Section 45 defence. And then finally, they move on to the public interest. And in considering the public interest, the prosecutors have to consider all of the circumstances of the case, including the seriousness of the offence and any direct or indirect compulsion arising from the trafficking situation. But it's worth noting that it's not just the CPS guidance on reviewing trafficking cases. It's important also to consider other relevant guidance, such as CPS guidance on youth offenders and CPS guidance on suspects and defendants with mental health conditions, because we know that most of our victims of trafficking have mental health difficulties. So it's worth bringing that in. And given the amount of time, I mean, I can't even count the number of case management hearings some of these cases have, and how long it takes to get to trial. It's worth keeping in mind the guidance on coronavirus and the backlog that they're really trying to clear. And if you're going to discontinue any case, it really should be one where you've got a child victim of trafficking. So it's worth also considering that aspect. So the next thing is to consider any expert reports that could be quite helpful. So for example, psychiatric reports, especially where you've got mental health conditions that mean the child is more susceptible to exploitation, or means they'll find it more difficult to say no. There will be issues in terms of admissibility, which I'll discuss in a moment, but it's also worth considering any trafficking decisions that, any trafficking expert that might be helpful as well. And then in terms of disclosure, this is shockingly bad at the youth court. I mean, I'm involved in a case where months after the first appearance and after multiple directions for disclosure by a given date, we still don't really have any disclosure. And pretty much all of the disclosure that we've had has come from the local authority. So it's worth staying on top of this and being proactive. Consider whether the child may have made, for example, if the child has a previous history of offending that is related to the circumstances of exploitation. Have disclosures been made to solicitors previously? Have disclosures been made in previous interviews with the police, even if it was a no comment interview on that occasion? Consider whether disclosures by the youth, by the child, have been made to youth offending team, GP, school records. Also consider asking the police for disclosure on any incidents reported to the police which relate to the defendant, any documents, investigations, meeting minutes or emails relating to reports of the child being missing, any correspondence that was shared between the local authority and the police in relation to the defendant, any mapping and safeguarding meetings, and importantly, any police investigations into persons who may be linked to exploiting the defendant. In my case, at the moment, we've got the local authority saying that someone's been arrested for human trafficking and the police saying, no, that hasn't happened. So it's about really chasing all the avenues that you can possibly find. Sorry, I know there's something. Okay. So moving on to admissions, tactically, this is something that is very, very important for cases, as if we can get as much agreed with the prosecution as possible, then we can raise as many points as possible during the prosecution case, because it may be the case that the defendant doesn't then give evidence. Now, you've already heard from Henry about the difficulties with agreeing the NRM decision and whether this is now going to be held admissible or not in the case stated. So we'll wait to see how that plays out. But if you've got a sensible prosecutor, it is worth agreeing the NRM decision. It's also worth getting judicial intervention on this, because I had a case where the prosecutor was just not agreeing to admitting it as an agreed fact. And the judge just said, well, I can't see why not. That seems like something sensible to do. And the prosecutor caved. So it's worth raising that and the duty of the prosecution to narrow down the issues and to either give us evidence that they're going to rely on to disprove the fact that the child is a victim of trafficking or to agree it. Other things you might seek to agree are mental health diagnoses, because obviously those are important as relevant characteristics in the defence. Any missing person reports, any previous convictions where they're relevant to the period of exploitation. And where it's not possible to admit the NRM decision, be prepared for legal arguments on admissibility. So at the moment, the issue is unresolved and it is pending, as Henry said, a judicial review. But the case that I found quite helpful was the case of Crown against SG, which the relevant paragraph says that had the first tier tribunal decision and the competent authority minute been available at the time of trial, we regard it as overwhelmingly likely that in the interests of justice and fairness, the Crown would have been required to make admissions as to their recognition of the applicant as a victim of trafficking, so that in practical terms, any admissibility difficulties at trial would have been resolved. And that's quite a helpful case to argue that this should be, this decision should be agreed by the CPS. But even where the CPS entirely dispute the decision and don't want to concede it as an agreed fact, it's still worth making an application to admit the decision as hearsay under section 114(1)(d), the interests of justice, on the basis that the decision maker is giving admissible expert opinion, because the single competent authority is an expert decision maker in this case. Now, even where, for whatever reason, it's not possible to admit the decision at all, you can still rely on the underlying facts that give rise to the decision, and that should be sufficient to raise the evidential burden and then flip the legal burden back onto the Crown to disprove. So consider things like indicators of trafficking and trying to get those into evidence. So, for example, any missing person reports, whether the child was arrested miles from home, whether they were arrested in the company of adults, whether they had in their possession cash or material belongings which would otherwise not have been affordable, or quite the opposite if they're found in destitution. And tactically, it is worth considering getting these in as much as possible during the prosecution case, as I said, because at times the defendant might not give evidence. In terms of psychiatric evidence, again, that may be admissible. For example, if you have a diagnosis of post-traumatic stress disorder, that's consistent with the traumatic events of the child having been trafficked. But also within the Section 45 defence itself, the second part of the test, so part 4, section 45(4)(c), says a reasonable person in the same situation as the person and having the person's relevant characteristics would do the act. Then in section 5, it defined relevant characteristics to include age, sorry, not section 5, part 5. Sorry, just making sure I'm still on the right screen. The Act then defines the relevant characteristics to include age, sex, and any physical or mental illness or disability. And the relevant characteristics therefore mirror the common law position in relation to duress, which is that a recognised mental illness is a relevant characteristic. So a psychiatric report is important in order for the bench or the district judge to be able to even go through the defence. So that's another reason why it's really important to try and get that in. The next point to make is to try and get as character references where your child is of previous good character, and even where they're not, if there's any evidence of them moving away from those influences, for example, any of their care workers since then, and to talk about the progress that has happened. And again, that's all part of showing the nexus and showing that once the child has moved away, this is how their life has been transformed. And the final point to note is in terms of mitigation. Of course, even where the defence is run, but the child, a finding of guilt is made, the being a victim of trafficking is something that you can still rely on in mitigation. But one thing I wanted to highlight is that even where Section 45 was never engaged, it's worth considering this, because I had a case in the youth court recently with a knife point robbery where there were no issues of trafficking raised at all, and I managed to get the youth offending team report early, and there was just a line in there about there's a risk he'll be exploited in custody. And I thought, well, hang on, is this just a general risk of a vulnerable child being exploited in custody, or is there something deeper, and we followed this up and found that there actually was a reasonable grounds decision that the solicitors weren't aware of, I wasn't aware of, and months later there had been no follow-up, and it's still waiting on a conclusive grounds decision. And using that in mitigation, I think, was instrumental in keeping the child out of detention. And just as a final point, these cases can be quite complex, especially if you've got multiple issues going on, mental health, exploitation. And in my experience, it's not straightforward to get a certificate for counsel, because most benches or DJs now consider that the Modern Slavery Act is something that everyone kind of can work on. But if you've got any additional issues such as mental health, it is worth making the application, and it's likely to succeed. Thank you.
Thank you so much, Fatima. There was a wealth of information in those slides that are a fantastic guide to anybody facing, representing a child who may or may not have been a victim of trafficking, in terms of the issues that can be explored to provide evidence and help support raising that defence and identifying whether it might be available. So thank you so much. And I think there will be questions later, but we'll come back to those at the end. We're now going to turn to Jo Cecil, who I know has been having a few technical difficulties, but I hope she's there even though she's not on the screen. Jo really is a child specialist barrister. She has been involved in many of the legal challenges to identify and protect children's rights in criminal cases. Most recently, in the case of TI, which explored the right of children to have intermediaries in that case, in a youth court case. So we turn to her now, and she's going to take us through how the ECHR and ECHR rights can be used in cases involving children in the criminal jurisdiction. And we're doing this partly because historically children's rights arguments have not been sufficiently argued in the criminal jurisdiction, and we're really hoping to encourage the audience to identify issues that can be raised and to develop the law more fully in this area. So I now turn to Jo. Thank you, Jo. Nice to see you.
Nice to see you too. I'm just going to beginning to share my screen, I hope. It says. Excellent. Okay, so I'm going to talk today, as Kate has already explained, about convention rights and more broadly how those can be used to when representing children in the criminal justice system. Perhaps to begin with, it's notable that there is a reluctance, certainly in my experience, to properly engage with those arguments when it comes to articulating Article 6 or Article 8 or whichever article it may be, and in particular Article 14, which we've really not yet got to grasp with in a criminal justice concept. And the result of that ultimately is because the approach of the court when it comes to criminal justice matters is that we know exactly what we're doing. We're world leaders in how we conduct our criminal justice system, and we have our common law traditions. And we have that arrogance in our courtrooms that Article 6 adds nothing to those, and certainly any international law provisions that flow through those convention rights when they're engaged similarly add very little, if at all. But as we'll see, actually, the ECHR has been responsible for some of the most significant changes within our criminal justice system over the years. But it's worth sounding that note of caution at the beginning that most of the time when you're arguing these sorts of points, you're going to be met with quite a degree of resistance, and there's no point pretending otherwise. But it is worth nonetheless having a look and certainly putting those arguments forward, because ultimately they do flow through, certainly in the higher authorities. I think if we could get to the Supreme Court a little bit more often, we'd probably have a few more favourable judgments in that regard. So a whistle-stop tour then of very recently, what sorts of cases have utilised convention arguments? So taking us back to the police station, strip searches. So relatively recent case involving a child strip searched in the police station and looking at those provisions within PACE, the lacuna effectively that took place in relation to 17-year-olds. The convention in that arguments in that case opened the door to huge implications ultimately, because as you will all know, there are now appropriate adults available to 17-year-olds. They weren't previously, and other aspects in relation to the actual PACE provisions. Trial, where really do convention rights bite the most? Well, obviously that's in terms of effective participation. And large number of those children that we represent, unfortunately, form a demographic with learning disabilities or other forms of disabilities or cognitive difficulties. And so really getting to grips with effective participation and true and proper Article 6 rights in that concept, in that construct rather. And then intermediaries, as we'll see as we go through, intermediaries really are probably one of the most recent developments, stemming all the way back to what is probably the seminal case in relation to convention rights and children. And that's going all the way back to Thompson and Venables back in 1999. And as I say, intermediaries really flow through and the developments that took place and came out of that. And then if we move to sentencing, well, convention rights again articulated now when one's dealing with reporting restrictions, typically in the Crown Court at the end of very serious cases. Should a child's name be made public? Should the press be able to report on that child's name? And often we'll see as I'll go through Articles 8, Article 10, but also importantly, frequently Articles 2 and 3 being engaged. I'll touch on that a bit later. We see it also, don't we, in the administration of sentences. So the parole board, delays in the parole board process under Article 5.4 being held to be unlawful. Damages can flow from some of these convention rights, albeit in the context of criminal justice, very, very rarely, and certainly very modest damages indeed. We've also seen convention arguments utilised and deployed successfully to the former IPP, imprisonment for public protection sentences, and the old EPP sentences, most pertinently really in the area of the provision of courses and resources really not being an answer when convention rights are in play. So touching on Article 6 very briefly, as I said, the most significant impact that we've seen within the criminal justice system, in my view, really does stem all the way back to 1999. You'll all be more than familiar with the facts of this particular case. Truly horrific, obviously shocked the nation, was being followed day by day in quite sensationalist reporting, continues to actually be reported on in those terms even to this day, despite the anonymity orders that were necessary to be made for those two defendants. In short, there were no adaptations to that trial process. The trial was conducted in the full glare of the media, children sitting in the well of the court looking up into these whole traditional courts, and very little, some might say, in terms of effective participation. So off that went to Europe, and albeit that as you will all be aware, the ultimately the convictions obviously were upheld and so on and so forth, but it did result in an important document by the then Lord Chief Justice, Lord Bingham, dealing with a practice direction to try to ensure compliance with a child's right to a fair trial. And what we have seen are significant adaptations and minimum standards of practice now within our courtrooms moving through. That's not to say that they're perfect. And certainly in a moment, I'm going to come on to another example, which perhaps shows us that we're not actually as far forward as we'd perhaps like to believe from 1999. But that practice direction is an important one. It's been modified over the years. We're currently living with its most recent iteration, amended again 2 years ago in relation to intermediaries. And that's why I say, ultimately, when we look to the intermediary aspect, really the genesis goes all the way back to Thompson and Venables. In 2013, importantly, for the first time, children were recognised as vulnerable people. Astonishing, really, when you think how long that actually took to come about. And the starting point, as I put at the bottom now, is the presumption that children require additional assistance and that those criminal proceedings ought to be adapted to their needs. So how successful is that, and where are we now? Well, I'm going to talk just very briefly, if I may, and indulge myself in a case that still, I'm afraid, I think causes both me and Henry to have nightmares. And it's the case of Grant Murray and others. Grant Murray and others, it's a conjoined case involving two defendants with significant difficulties and disabilities, autism. and then conjoining that with a case involving several children. It dealt primarily with issues of joint enterprise, and that's one of the reasons why they were joined, so that the Lord Chief Justice could make proclamations on how Jogi would apply in those sorts of situations. But the issues in front of the court were far broader than that. And certainly in respect of both my client and Henry's separate clients on this occasion, there were significant similarities. In short, the trial took place in Liverpool. It was a high-profile trial with the press following it. So far, so many similarities. As you can already see from what's on your screen, it was punctuated by fairly unusual behaviour, some might say, such as an individual, one of the defendants, setting somebody else's hair on fire in the dock, in the room, the ante-room to the dock. There were no trial modifications that were of any import or any significance. My client, I don't think, was asked a single question that wasn't tagged, and bearing in mind he fell in the bottom 2% of the population in terms of cognitive ability, one might say that was particularly shocking. Henry's client, similar situation. Ultimately, conviction upheld, found to be safe, those children could effectively participate. So you have to ask yourselves, ultimately, how far are we from 1999, when the European Court last looked properly at the issue of effective participation for children within the UK justice system? Arguably, it's not necessarily that far along. The one good thing that did, however, come out of Grant Murray is ultimately the emphasis now that is to be placed upon the role of children within courtrooms, the emphasis and the need potentially for intermediaries, the extension of what were typically seen as being provisions for vulnerable witnesses and complainants to defendants, and for the first time in terms of trial management, the court actively having to engage with issues pertaining directly to the trial of those children. So identification of vulnerabilities, identification of needs for breaks, identification, importantly, as to whether or not those children should be sat in the dock. And we are seeing some of that coming through and into fruition. Certainly at the Bailey, a number of cases have taken place with children outside of the dock. Set against that, there have been some unfortunate instances you may have seen in the press, and that seems to have coloured more recent developments in that regard. And of course, very, very few courts are currently sitting. So moving on, just wanted, as I say, to touch on Thompson and Venables very briefly. The greatest strength in many respects of the convention arguments are that when articulating and engaging a convention right in your submissions and in your case, that becomes a window through which international law provisions then flow. And I've put on there a couple of cases for you. I'm not going to go into those in any great detail, but as you can see, ultimately, provided you can find that sufficient nexus, then you can rely on the UNCRC, the Beijing rules, those types of things, and those flow through. And that's important, not least in relation to the classic articulation of the UNCRC that we're also familiar with, or at least I hope we're also familiar with, but also in relation to the CPRD, the Convention on the Rights of Persons with Disabilities. And as I say, that's really an area that we've not yet utilised in any meaningful sense, actually, within the criminal justice sphere. But to give some quick examples of how things flow, we've got the best interest principle, and you can see here that mainly in the context of extradition cases, the Supreme Court has emphasised the importance of that and its enforceability in domestic courts. As I've set out underneath, be imaginative, because as I said at the beginning, unfortunately, many of our children suffer from disabilities. It's a hugely disproportionate cohort within those children that come before the court. And so really one should start to look at additional rights that are afforded to them under the UNCRPD. And I set that out because if we continue through it, you see the right to equality before the law, equal access to justice, and right to liberty. Well, what does that actually mean in practice? Well, it's arguable that the test to be applied is not simply whether the defendant can have a fair trial, can you meet that minimum standard, but more broadly, whether they enjoy that same ability to participate as those who are not subject to that disability. And the government has actually recognised this in public pronouncements, although I've not seen anything, frankly, that really mainstreams this in any meaningful sense. going on through, the other great strength of the Convention is the standard of review upon appeal. And I'm going to touch upon, as I said at the outset, reporting restrictions very briefly as an example of how the test can be applied differently upon review. So you'll all hopefully be familiar with section 45. You'll all also know the typical arguments 2 and 3. So the right to life, inhumane and degrading treatment, typically arising, in my experience, in those cases where retribution and the like are high on the agenda. Then you've got the Article 6 rights, Article 8, obviously a more nuanced right, much lesser weight than Articles 2 and 3, and then Article 10. And traditionally, when it comes to a section 45 argument on review, and indeed in the court at first instance, you're applying the traditional balancing exercise. So balancing all of these rights into and putting them all into the pot, where does the balance lie? And obviously Article 10 is an extremely powerful right in that respect in terms of open justice. And then one looks at the common law too, and again, you're looking at that balancing exercise. But there are differences where and I've set out the balancing exercise here, which most recently articulated by the Lord Chief Justice in the case of Aziz, dealing with the standard of review, both in judicial review proceedings and indeed before the Court of Appeal Criminal Division. As you can see here, it's the exercise of a judgment. It's balancing those competing claims of privacy, welfare and open justice. Markham being the very high profile case presided over by Mr. Justice Haddon Cave, as he then was, involving the two, the couple the very young couple who murdered the girl's younger sister and her mother. So high profile, ultimately was named. And so, and as you can see here, the test there upon review is that ultimately the court will only ever interfere where the decision is plainly wrong. So we're nearing Wensbury unreasonableness levels effectively, or an error of law in terms of public law principles or is identified. But when it comes to Articles 2 and 3, which are obviously absolute rights, there's an argument that actually that requires a very different standard of review. It's an argument that's going to be advanced in a case next week before the divisional court and in a conjoined appeal with the Court of Appeal Criminal Division being presided over by the President. And it's arguable that the court actually has at that stage, both at the trial level, but also more pertinently on review, both that positive duty in relation to the protection of that right, but also when it comes to actually reviewing that decision that was made in terms of making, and it's called in the accepting direction is a technical term for effectively lifting the reporting restrictions. Whether or not you apply that typical balancing exercise, or do you take that much higher stringent standard of review where the court simply has to make the determination for itself, was it right or was it wrong as a decision? And so really what I hope to do here is to give a flavour of how of not just those types of cases where we utilise those convention rights, but more broadly, how the convention has seeped in and impacted upon the way in which we articulate our arguments much more widely than simply honing in on what does Article 2 say and what does Article 3 say. It ultimately goes to issues of construction. And I just want to now move on, if I may, very briefly indeed, because I appreciate we're probably moving towards a time limit here, and everybody I'm sure has lots of questions. A couple of areas which, in my view, are still ripe for challenge. So mandatory life, or rather detention for Her Majesty's pleasure in relation to children who commit offences of murder, and also just touch upon briefly mandatory minimum sentences, so firearms, and certainly we've seen it with knife crime and the like more recently. So is there an issue there over compatibility, for example, with Article 3? There's also Article 8 considerations, but as I've already outlined, those considerations are to a much lesser extent because of the nature of Article 8. Well, there was a challenge in Thompson and Venables that failed. We made a similar challenge in Grant, Murray and others, but that failed. And in fact, leave was not even granted in that case. So that's why it hasn't gone any further, because we cannot simply take it any further, certainly into domestic provision. But the landscape had changed and is changing. And I think that's really important to keep one eye on these sorts of developments, because at some point, the court is going to have to properly grapple with these arguments. And so in 2016, the UN Committee on the Rights of the Child conducted its report of the UK, and it finally issued its concluding observations. Their recommendations there were to abolish the mandatory imposition of life imprisonment. The UN Special Rapporteur on torture and cruel and inhuman or degrading treatment, so effectively Article 3 in terms of convention rights, but more broadly, obviously, one looks to the ICCPR and other international instruments, concluded that life imprisonment ultimately amounted to cruel, inhuman and degrading punishment. And similarly, if you read the second part of that quote that I put here, the Special Rapporteur found that the mandatory sentence was incompatible with the state's obligation regarding children in conflict with the law. And so one has an issue that not only in relation to the mandatory sentence of detention at Her Majesty's pleasure, but also in relation to mandatory minimum sentences. And here I've just set out here the aspect in relation to mandatory minimums. Another aspect currently topical, some of you, I've touched upon this in a different seminar, albeit these are different slides, I promise you that. Certainly most of them are. Custody time limits and convention rights. So obviously in the aftermath of COVID, you'll all have know that the custody time limits have been lengthened, owing ostensibly, certainly on the government's basis, to the fact that COVID has produced this huge backlog. Now, many of you will know that's not the truth, and that's simply not true. And the backlog existed pre-COVID. It may have been exacerbated by COVID, but certainly the issue is more attributable to the cuts to the criminal justice system, and certainly to the cuts to the court sitting days. So speeding very quickly through this and just taking you to the most relevant parts, set out some of the background there, which you'll all have an opportunity to look at previously. The new regulations came into force in September. And so they are now starting to bite on those children who are appearing before the court in new matters. It's not retrospective. So we're looking at children who are detained post 28th of September 2020. And if any of you have those children, please get in touch, because we're currently in the midst of pre-action correspondence in relation to a challenge on the basis of disproportionate impact upon children and BAME children in particular. It has the impact of extending the time by approximately 2 months before the Crown have to make the application for an extension of the custody time limits. No parliamentary scrutiny, as you can see here, secondary legislation, a negative procedure in actual fact, moving through. So cutting through some of this, the initial public sector quality statement stated that there had been no full impact assessment produced because they could see no significant impact on any particular sector. They hadn't bothered consulting the Children's Commissioner, again, probably not a great surprise given the current government. So no impact. Is that true? Well, it's plainly not. We've seen an increase in remands. The proportion of those individuals who were subsequently acquitted are very high indeed. You can see here in 2019, we had 3,000 people. Of children, 45% of children in prison were on remand, compared to 37% of adults. So one sees immediately this provision is going to have a disproportionate impact on children. And interestingly, 48% of those remanded in custody who were subsequently convicted did not receive an immediate sentence of imprisonment. So these are the types of issues that we're playing with. We're playing with innocent children, children's lives, and then we're also playing with children who will not receive any meaningful custodial sentence at the end of it all. We're seeing an increase in vulnerabilities and self-harming within custody, mainly owing to the fact that they're in their cells at least 23 hours, if not more, a day. And you can see here a 66% increase in the self-harm rate. That was just in March of 2020, and since then it's got worse. BAME implications. So 20% of adults are remanded. We see here 40% were black as compared to 38% of white defendants. And that was despite those black defendants being less likely rather than white defendants to receive a sentence of imprisonment at the conclusion of proceedings. So you're seeing immediate disparities here in disproportionalities. And similarly, one sees the third of children. the government accepts that these are issues. They accept that custody should only be used as the last resort for children. ECHR, the Child Sex Abuse Inquiry, made very specific recommendations. And as a consequence of that, the government, at least in theory, committed to consider the use of remand. But they'd aimed, apparently by this summer, to reduce the number of children upon remand. Obviously, that's not happened, and we're seeing the opposite take place. So earlier in September, the Howard League Liberty and Just for Kids wrote to the Attorney General, the Lord Chancellor, and the Prisons Minister. Then we were told at that point that they'd conducted that impact assessment. They had actually conducted an impact assessment. My sneaky suspicion is that they did it as soon as they realised that they had a letter in their inboxes, but there we are. It was a very poor assessment. No child rights impact assessment had taken place. That accepted that there was indirect discrimination. It accepted that disproportionate impact. Accepted that in relation to the two cohorts, both BAME and children were disproportionately impacted. So of course one has to ask, what about those children who are both? But nonetheless said it was justified. So what can we do in relation to convention rights? How can we use the convention? Well, we can use Articles 5.3 and 5.4, traditionally used in the prison law context in relation to a speedy review of lawfulness of detention. Here we see that potential delay in that judicial oversight, and you will all be aware that when the courts are currently fixing trial dates, they're trying to fix them within those CTLs. So the likelihood is that those trial dates are going to be within that latter period of the CTLs, as opposed to within 2 months' time at the present time, not least because those children in the Crown courts that are facing trial are often in those trials that are most difficult at the moment to actually get into court and get the show on the road. So children involved in murder cases at the Bailey, for example, some of the most serious cases, multiple defendants, those cases simply cannot be tried at any great rate. So those are the children that we're talking about. So what does the Council of Europe have to say about it? Well, they say that there should be a maximum of 6 months for children to be in pre-trial detention, which can only be extended by exceptional circumstances. Strasbourg, so the European Court, has held a failure to take into account the age of a minor is a factor which amounts to a breach of Article 5.3. So we've got the, as I'll move on to shortly, the government's duty to effectively treat different cases differently, and plainly that must involve to treating children differently, one would think, to adults. And then they've looked at a couple of cases, primarily in relation to Turkey, as to time on remand. And in Turkey, what they held was that 4 months and 48 days on the facts of those particular cases was simply too long and in breach. So I think there are some quite interesting arguments about Article 5.3 and Article 5.4 to be had. And again, you then have the international law that flows through. And as we can see, going back again to Strasbourg, the failure to take into account the UN Convention on the Rights of the Child, and let me be very clear, there's no mention of that in relation to the impact assessment. Why would there be? Some might say, if you can't even consult your children's commissioner, was a relevant factor in considering the lawfulness of a minor's detention. In addition, you've got Article 14, so we're looking at discrimination there in conjunction with Article 5. Article 14 is always effectively parasitic to one of the other convention rights. So we've got that recognition of that disproportionate impact. We've got that failure to treat different groups differently. And importantly, also the positive obligation on the state to combat discrimination. And what are they doing about that here, one has to ask. Again, their response simply at the present time is that it's justified by COVID. It will be interesting to see what the final defence or response is in that regard. And that's really where I plan, hopefully, to round it off. Say thank you to you all, and hopefully you'll have some questions. Thank you, Kate.
Thank you so much, Jo. And she has helpfully taken us through not only an overview of how the convention has been used in litigating children's rights in a criminal context, but also horizon scanning and where we might see future developments, and also to highlight to you in the audience the sorts of cases you should be looking at as being susceptible to challenge. So we have got a Q&A function, but it hasn't been flooded with questions. The first question came from Sandra Beaton, who said that she would have to leave the discussion, but she was asking about the 2012 strategic policing requirement placing a duty on chief constables and police and crime commissioners to support arrangements for national threats, and notably absent from those national threats was child criminal exploitation. This has been raised in an early day motion, but could this be challenged? I wonder, Henry, whether this is something you could make some comments on.
I was rather hoping Jo would be able to deal with that. She has her finger on the pulse in this area.
I mean, it is remarkable given the awareness that the police do have about the levels of exploitation of children, particularly in terms of county line gangs, and particularly the consequence of lockdown, the fact that so many children fell out of education because they weren't attending school, and then maybe that they'd reached a threshold and didn't have any arrangements made for them. So there are a lot of children who are sort of lost in the system, and there's been a lot of alarm bells raised about their risk of exploitation. So I think, I don't know whether, Jo, you did want to come in on that.
Unmute myself. It's I'll be frank, without looking at it very carefully, it's very difficult to say, but it would appear that certainly that a potential line of argument would be the positive obligation of the state in relation to the Palermo, oh gosh, can't even speak now, convention, and also the various provisions in terms of Article 4. So certainly that's one aspect and one avenue. Given the, I don't know what the status of the early day motion is. I assume that it hasn't actually taken place yet, and that may actually be more fruitful, because certainly, at least in terms of trafficking and child sexual exploitation, and I appreciate child sexual exploitation is already included, there has been a greater willingness, at least, to incorporate those aspects into matters at a very ostensible level, even if it's not working on the ground and we're not really seeing the fruits of it. So that may be a more fruitful avenue if, as it appears, politicians are already on side.
I mean, what I would say by way of addition is that police forces are certainly alive to the whole human trafficking issue, and in my experience, are reasonably well educated about it. I mean, you do find more often than you might think that in fact decisions are taken not to prosecute children who are caught up in county lines offences. So they know about it and they're on top of it.
Thank you, Henry. The other question, in fact, I think, Henry, you've already answered, which you've regained your status as being technically adept.
Well, the funny thing is that on my screen, the answer's disappeared.
So this was a question from Calvere about whether the non-punishment provision is capable within the Modern Slavery Act. I think he was referring to was capable of being applied to charges of terrorist activity, or and of course this is the real issue, which is that was raised in Henry's overview, which is that many terrorist offences are excluded from the Section 45 defence because they are listed in Schedule 4 of the Modern Slavery Act, and therefore the defence cannot be raised, and that's why the use of the abuse of process mechanism in order to give effect to the non-prosecution principle, which at the moment is one that the Court of Appeal is saying is not available, as I understand it, Henry.
Yeah, well, in A, they effectively said that you can't use the attenuated protection of abusive process. In other words, you have to use the sort of strict criteria and ex parte Bennett, state malpractice, effectively. That's what it comes down to. So it's not really effective. Sections 1 and 2 of the 2006 Terrorism Act are not in Schedule 4 rather. So that's the offences of dissemination and encouragement, glorification. So they're not covered. So you can run a Section 45 defence if you're charged with those offences, if it's appropriate.
And that's really helpful. So where do you see if I may, Henry, ask you, where do you see the law developing if in domestic courts it's going to be hard to raise arguments where certain offences are excluded from the Modern Slavery Act, but that is supposed to be giving effect to these international obligations that we have? How do you think the law will develop in the criminal courts?
Well, I mean, there is an argument that Schedule 4 is incompatible with the anti-trafficking protections, and I suppose by extension with Article 4 of the Convention. But it's you need to find the right case to take it, because the principle that the seriousness of the offence is relevant to the question of the public interest in prosecution is well established now. And what the Modern Slavery Act does, in effect, is to give statutory effect to that principle. So it's. I mean, I'm afraid the reality is it's difficult, if not impossible, to challenge a decision once the decision has been taken. I mean, you can always make representations, and I have to say, I thought the Fatima's talk was absolutely fascinating in terms of just taking us through the practical steps that you need to take in order to develop and pray and aid the Section 45 defence. And you may very well find that you can, as a result of that, make some progress and stall the case. But if they decide to prosecute, then increasingly it's very difficult to be able to put a stop to it, I'm afraid.
Thank you, Henry. I mean, it does seem that we may have seen, there may have been a high point in terms of the opportunity to avail defendants of this defence. And certainly, anecdotally, we're hearing that the CPS, who previously were quite receptive to representations, have been more resistant to doing prosecutions when these issues are raised. And I think we have to be inspired by Fatima's talk this evening. I mean, she just shows the tenacity of a determined advocate does end with the best outcome for their clients, and that it's not good enough just to make one set of representations. It's not good enough just to make two. You've got to keep trying if you know that that is the just result. And you have to garner as much evidence as possible. And I think what was really helpful about your talk, Fatima, was it showed just how broad the areas you can go to get the evidence and material that you might need in order to provide the CPS with an unassailable amount of material for them to make the right decision. So that was really helpful, and I hope that it will be a sort of practical checklist that those participants on this webinar this evening will be able to take away with them and put into practice. So we are drawing to the end of this talk, so it just gives me the opportunity to say thank you so much to Henry, to Fatima and to Joe, who have all, as you have seen, put a great deal of work into preparing for this seminar this evening, so they're able to share both their expertise and give us a broad overview of both the historical context to which brings us to the current position in relation to using convention rights when in cases involving children in the criminal justice system, but also where we may be going in the future. I think that we've all been encouraged to work harder and dig deeper in terms of finding ways in which we can ensure the best outcomes for children. And it's this approach that we're hoping that we will bring by launching this evening the Youth Justice and Child Rights team. We want to champion children's rights, and although we're in the context of a declining number of children coming into the criminal justice system, over the last decade we've seen a 78% fall in children coming into the criminal justice system, or what we have seen is that the cohort are increasingly vulnerable, and the Justice Committee's recent report on children in custody identified that many of them are the most vulnerable children in society, many having mental health issues, learning disabilities, and experience of care, and that really the youth justice system has to adapt to meet their needs. And of course, although we have seen this decline in children coming into the criminal justice system, what we haven't seen is a decline in particularly Black children in the criminal justice system. And while the decline has been seen, we've also seen, unfortunately, and particularly in the last 5 years, proportionately many more Black children in particular who are being prosecuted and being convicted and sentenced, and they are being the Justice Select Committee report identified that Black and Asian children in particular were here receiving higher proportions of immediate custodial sentences. So Garden Court wants to be here for you, and in terms of ensuring children get the highest quality of representation, and that we buck that trend and ensure not just this work that Henry has been at the forefront in leading in terms of protecting children from criminal exploitation, and the work that Joe has been done to afford children's rights are protected in a criminal justice context, that continues and reaches all children in the criminal justice system, so that we can protect their rights and ensure as many of them as possible are not criminalised, and those who do get the best outcomes possible. So thank you so much for joining us. You will receive copies of the slides, and we look forward to you joining us next time. Thank you very much, and have a lovely evening.